I don't know why. Sometimes you flip the screen over, the shit. I don't know what happened. Sometimes you flip the screen back and forth, the live clip off somehow. But I need, when people get back in here or watch it on a replay, watch the first video first. I need everybody to understand that, yo, that this is a bond hearing, yo. We're not here. What's up, Hardma? We're not here at this moment to dispute all the facts of the case. We're not here to do that. Just minor details. And in this case, we're just disputing the mind frame. Because that's what the government's going to have to prove. They're going to have to prove that intent was there. So what we're doing in this motion is we're coming after the intent. Because in order to say Big 30 was a part of this this robbery / kidnapping, you're going to have to prove that his intent was to do that. Similar to, what's the girl name? Alicia Andrews. They struggled with finding her guilty because they couldn't prove her intent. They couldn't prove her intent. Yeah, you got her in the car. We see her get out the car. But how do you know for certain that she was a part of this murder? She could have just been there. And in this case, at that rate, why is he at no bond? What if he was just there? What if he handed him this bag and he just thought it was just recording equipment? What if he was just as surprised that when the Drake came out? Yo, niggas just don't know how to understand court paperwork or break it down correctly. Like, you're over that bitch standing on some shit and he's all the way wrong about it. All the way wrong about it. And I stand on the fact that he did wrong for that. He did wrong for that. And he know it. He know it. That's why he got so angry. He know he did wrong. He know what he's saying don't make sense. He know that legal term that he's using doesn't apply. Look, a federal judicial admission, deliberate, clear, and unequivocally statement of fact that binds a party and withdraw a fact from contention are not limited to a single type of hearing, but are typically finalized or utilized during pretrial conferences and hearings on motions for summary judgment. That's all I was saying, y'all. That's not something that happens at a bail hearing. He's using that term. He's confusing people. You don't make a judicial admission at a fucking bail hearing because it's binding, which means you can't back out of it. And he presented that like, yo, they can't back out of that. What I'm saying is they just used that because it made the most sense to use to get Big 30 a bond. That's what he's wrong at. That's what he's wrong at, yo. It makes the most sense to use that. If all y'all saying is my client stood in front of the door, handed him a bag, pulled out his phone, I run with that for right now. Yeah, for right now, I will run with that. Not forever, but for right now, I run with that. What's up, G, man? If Larry did, everyone that lawyer need to get an answer. And I guarantee he gonna say what I said. Like, yo, the nigga is wrong, yo. That's why I told him, Homo, you was there. That's why I said, yo, so basically what you saying is, in court, come trial time, they're going to admit they're not going to fight this. Because that's basically what he's trying to allude to. That Big 30 lawyer is not going to fight none of this. He basically going to say, yeah, I did give him the bag. Yeah, I did record it. Yeah, I did stand in front of the door. But it wasn't because I was part of the criminal organization. Man, that shit sound fucking stupid. Nigga ain't gonna do that, man. What kind of like that shit sound like yo Byron knows better than that? Or at least I thought he did. Now I'm having questions. He used that term to mislead the people, man. That's what he did. Motherfuckers don't make no judicial admission at no fucking bond hearing, man. It ain't time for that. Did y'all hear the hearings? Let's look at the hearings again. Oh, let's see what let's go to this shit. Oh shit, this shit small as a bitch. Formal admissions that have the effect of withdrawing a fact from issue and dispensing wholly with the need to prove the fact that issue. Formal admissions that have the effect of withdrawing a fact from issue. Okay. All right. All right, so look at this. So, he right. Look, but he's wrong at the same time. Listen to this. A judicial admission are formal admissions that have the effect of withdrawing a fact from issue and dispensing wholly with the need to prove the fact at issue. So basically, like I said, we're conceding at this moment. We're conceding to everything the government said, but that's where the this part come in at. We're going to withdraw a fact from the issue, basically by the government saying that he was a part of this wholeheartedly. We're withdrawing that fact because we don't believe at this time we don't believe that's true. We don't believe that's true. He was just there. You understand what I'm saying? And all this is done for bail. They're not being binded by these statements like he's trying to make people to believe, because it's not time for that. Hold on. This shit's small as shit. If amended, become binding as long as statements were not the product of mistake or indifference. Similar systems contained within answers to interrogatories may include judicial admissions, however, statements. All right, let me send this to my email so we can read this. Like, yo, he applied the rule when it didn't fit, yo, and he misled people, man. And he trying to make it seem like I'm wrong. Nah, my nigga, you wrong. You wrong, bro. Hold on. What's up, Charlie Pie? Man, going, man, this motherfucker Byron Blake over that bitch not trying to accept accountability for being wrong and misleading niggas. Then get mad at me for calling him out. What are judicial omissions? Judicial omissions are formal omissions that have the effect of withdrawing a fact from issue and dispensing wholly with the need to prove the fact at issue. Which means they're going to have to prove that. The government is going to have to prove that these things happen. Statements made in pleadings, during testimony, open court proceedings can be judicial omissions. Additionally, statements contained in an unverified pleading signed by the party attorney can be a judicial omission and binding the party to statement. The party. Statements is verified pleadings, even if amended, become binding omissions as long as the statements were not the product of mistake or indifference. Similarly, statements contained within answers to interrogatories may constitute judicial omissions, which means in interrogation rooms. However, statements made in the course of other proceedings cannot be judicial omissions, but are considered evidentiary omissions. Routinely held that the party making the judicial omission is bound by the statement made. Courts are cognizant of the binding nature of the judicial omissions and are carefully in considering statements as judicial omissions. In chance, the statements made was by a nervous party. Given the binding nature of the judicial omission, there are several factors that must be met for the statement to be considered a judicial omission. In order for a statement to be considered a judicial omission, it must be deliberate, clear, and unequivocally statement that is within the party's knowledge. It cannot be a statement concerning a matter of opinion. A matter of opinion. A matter of opinion. That's what we're dealing with right now. Estimate, appearance, or inference. When determining whether a statement is so unequivocally indeliberate as it constitutes a judicial, like, yo, this is a high bar, y'all. Do you hear? This is a high bar. Like, a nigga's wrong. He wrong. Look how high this bar is. It cannot be a statement concerning a matter of opinion. That's why he can't. That's why he used it in the wrong context. Estimate, appearance, or inference. When I was saying, like, we had a bond hearing, yo, ain't nobody making no judicial omissions at no fucking bond hearing, man. When determining whether a statement is so unequivocally and deliberate as it constitutes judicial omissions of a fact, a court is required to consider the person's entire statement, not just isolated portions of it. Further, in determining a statement is unequivocally, a statement whether it's unequivocal, courts look at the ambiguity of the statement. If the statement is so ambiguous that the court will find it as a judicial omission. Yo, get the fuck out of here, man. That nigga dead wrong. Nigga dead wrong, man. So basically, all of this happened and all of this happened just now. This sounds like a whole fucking hearing. It sounds like to make a judicial omission, it damn near basically got to be a whole hearing. They don't know what the fuck he talking about, man. Nigga don't know what the fuck he talking about. Look, in Lowe versus Kane, so this is the case law that they're using to explain it. A statement made by defense counsel in closing arguments was ruled a judicial omission. Closing arguments. Not a fucking bail hearing, man. Oh, y'all, I don't need to keep going. Y'all nigga don't know what he talking about, man. Nigga with that bitch loud, wrong, and ignorant. And he got people believing that shit. Exactly, bro. Exactly, Money Mitch. If they wouldn't even be asking for no motherfucking bail, man. Like, yo, he basically made it seem like the nigga pled guilty at the bail hearing. Come on, y'all. Try to make me seem like I'm fucking wrong. Nigga, you wrong as a bitch, nigga. Wrong as a motherfucker. That's why I said in the video, ain't no right in it. Look at the case law they using. Law versus Kane. In closing arguments. That means we done went past motions. That we done already had arraignments. We didn't bail here. Like, oh, come on, man. They don't know what the fuck he talking about, man. He just misapplied it. And that's all I was saying. I'm not disputing that that's a thing. I'm just saying, yo, you're using it in wrong context. The context that you're using it in isn't right. Let's continue. The plaintiff sued the defendant under a negligent theory for injuries she sustained as a pedestrian when she was struck by a vehicle driven by the defendant. The defendant denied he was negligent and asserted a comparative negligence defense. During closing arguments, defense counsel repeatedly stated that both parties were at fault and that his client should be only found 50% at fault. The plaintiff counsel then moved for a direct verdict on the issue of defendant's liability, asserting the defense counsel had admitted liability on behalf of the client. The trial court directed a verdict on the issue of the defendant's liability based on the statements made by defense counsel in closing arguments. Come on, y'all. Closing arguments. We talking about closing arguments. Not bail hearings. In upholding the trial court directed verdict in favor of the plaintiff, the appellate court reasoned that the attorneys, as agents for their clients, can make admissions on behalf of their clients in all matters relating to the litigation of the case. The court noted that the fact that the statements made by the attorney is made in opening court, closing arguments, or direct examination, or cross-examination is relevant to the context in which the statements is made and not determinative or whether or not the statements is a judicial admission. Listen. Direct examination, cross-examination, opening arguments, closing arguments. What the fuck is he talking about, man? Talking about a fucking bail hearing, man. Dumbass nigga. Nigga dumb as shit. And looking at the statements made by defense counsel during his closing arguments, the court found that the defense counsel stated unambiguously that the defendant was at fault for causing an accident. And when viewed in the context of the entire closing argument, the statements were clearly based on a theory and not inadvertently made. Additionally, for a statement to be considered a judicial admission, it must be known within the knowledge of the deponent, where there are multiple persons with knowledge of a thing, all with conflicting testimony. Courts will not hold their statements as judicial admissions. You understand that part? When there are multiple persons with knowledge of a thing, all with conflicting testimony, court will not hold their statements as judicial admissions. However, when a party makes a statement about a matter that only they know about, courts have held those statements to be binding. We talking about a situation where there's 3 people there. They all going to have different accounts of the situation. You heard Big 35 say, I wasn't even there. Nigga don't know what the fuck he talking about, man. Don't come over here making this nigga. Man. Come on, shorty. You're wrong, my nigga. You're wrong. Do we gotta continue? Or do people understand this nigga don't know what the fuck he talk about? Once a statement of fact has been ruled, look, this has to be ruled on. Like, man, get the fuck out of here, yo. Like, yo, that's what I've been meaning. Why I say, yo, the nigga is all the way wrong. That has to be ruled on. It has to be ruled on. Like I said, that shit damn near a whole nother court proceeding. It is binding on a party that the statements that made the statements the court have frequently stated that the purpose for judicial admissions is to eliminate the temptation of a party to commit perjury. As such, a party cannot introduce a contradictory statement in order to create a factual dispute, including but not limited to. Come on, y'all. That nigga wrong as a bitch. Nigga wrong as a motherfucker. Well, where's Jay and all them at? That was co-signing this dumbass shit. Now let's go back to what he said. Nigga wrong as a bitch. Now let's see, based off of what we learned about judicial admissions, let's see if this fit.
And forced him to sign the release paper. It says, Mr. Williams disputes that he was present in the recording room when his son pointed an AK-style pistol at RD.
Conflicting testimonies. That already rules out judicial admissions. That already rules out judicial admissions. There's no way that can be a judicial admission. Fuck boy. You dumbass. Don't know what the fuck you talking about. Try to challenge my motherfucking knowledge on law, nigga.
His head and forced him to sign the release paperwork, and that he directed that RD be forced to date his signature, as the government alleges. But as Judge Christoph observed, even in a light most favorable to the government, this evidence showed...
Fuck wrong with him, Snake House. Yo, tripping. Hey, Snake House. Fuck wrong with yo. Yo must think I'm Sonny Nash or one of them niggas. Don't ever fucking try to challenge me, nigga. I ain't even have to do all of this. I just did this for the non-believers. Nigga, you wrong, my nigga. Fucking judicial admission at a motherfucking bond hearing. The fuck is you talking about, man? Niggas ain't even got discovery yet. Like I said, on his live, how the fuck you gonna admit to something without saying evidence? How you gonna admit to something without saying evidence? What lawyer is gonna admit to something without saying evidence? So much so that it gets deemed a judicial admission, which you see have to be ruled on. Has to be ruled on. Has to be, it's damn near like a fucking confession. The fuck is you talking about, man? They gonna sit there and say the nigga ain't, I ain't say the nigga snitch. Yeah, you did, bro. And you was fucking wrong, my nigga. Now what you need to do is upload a video, motherfucking apologizing, and get that shit right. That's what a real nigga would do. Since you want to portray yourself as a real nigga, that's what a real nigga would do. A real nigga upload another video, apologize to me, and apologize to Big 30 because you was, matter of fact, apologize to the people that listened to that dumbass shit. Because you was fucking wrong. That's what the fuck you need to do, my nigga.
That Mr. Williams at most stood by and let it happen. Now, as I said, this is Shiesty's father.
Look, so we already ruled that there's no way when you got multiple defendants can you make a judicial admission. We found that out. You can't make a judicial admission when there's multiple people that witnessed the same incident. They all got conflicting stories. You hear his story. Fuck out of here, dumbass nigga.
You know, and one of the things that I want to point out is that he's saying that he disputes that he was present in the recording room when his son pointed an AK-style pistol at RD's head. Now, while this isn't a confirmation of his son doing it, because he says that he disputes that he was in the room, he does dispute that he was in the room. So now he is presenting a defense that he wasn't even in this room when any of this stuff took place. He's not saying I saw anything, I didn't hear nothing, I wasn't even there. Basically, that's his defense to this situation. Now, let's take a look at a recent document filed by Big 30. This was filed April 24th, and it says, as for Mr. Wright's undisputed conduct, basically saying this is something that we cannot dispute that happened. Retrieving a bag at another person's request, filming a document signing, standing at a door.
Yo, we just, hey, Byron, come on now. We just did it, bro. Do I got to go back to the document? Look at this. Look at this. Can you see this? You cannot make a judicial admission with multiple people giving conflicting statements. Hold on, where that shit go at? Rewind the video. Here you go, right here. No, don't move the goalpost. No, because this is what you stuck on. You stuck on you. This is the biggest issue that I had with it, bro. Like you started getting disrespectful, yo. I ain't disrespecting you, my nigga. I just said you was wrong, and you need to apologize for being wrong, bro. You need to get that shit right. You wrong. You misapplied the fucking legal term, bro. You misapplied it, bro. Look, here you go. For a statement to be considered a judicial admission, it must be within the knowledge of the deponent. When there are multiple persons with knowledge of one thing, all with conflicting testimony, courts will not hold their statements as judicial admissions. You're wrong, my nigga. You're wrong, yo. You wrong. Just admit it, my nigga. Like, oh, I can't believe you did all that, bro. Must have been supporting your motherfucking platform, my nigga. Way before niggas supported your platform, bro. You go over that bitch getting like over that. I really feel some type way about that shit, my nigga. Much as I supported your platform, for anybody supported your platform. I sent hella niggas over there. Look at niggas in the comments. Nigga, them niggas know you through me, my nigga. No, you didn't say it, bro. Your comment said it, bro. You alluded to it, bro. You alluded to it, bro. You know you alluded to it, y'all. You damaged that man's name, bro, and you wrong, my nigga. You damaged that man's name and you wrong, bro. And you know you did it, y'all. No, you didn't say he snitched. But yo, you applied a legal term when it didn't fit, y'all. You applied the legal term when it didn't fit, bro. Yo, judicial admission, yo, that shit damn near gotta be its own motherfucking hearing, bro. Like, yo, we talking about closing statements. Opening, yo, I'm looking at it. I'm not slow, you're wrong. We're talking about closing statements. Yeah, we talking about doing trial, bro. We talking about doing trial, bro. I don't say anything about what are you talking about? It don't say nothing about no opponent, yo. It say deponent. Knowledge of deponent. Look, now you want to fight. See, that's what niggas do, yo. Yo, I'm not ready to fight you, yo. I got respect for your platform, my nigga. You don't want getting emotional about it, bro. You got emotional on me, yo. I just said you was wrong. You was misleading niggas, bro. What the fuck I'm gonna meet up with you and fight, man? Where we gonna meet at? Motherfucking, where you at? We gonna meet in Ohio? Like, oh, come on, yo. Stop talking stupid, my nigga. You wrong, bro. Just admit you wrong. That's it. Upload another video like you did and was like, yo, my bad, yo. I got it wrong, yo. I applied the definition where it didn't fit. That's what the fuck you need to do, yo. That's what you need to do, bro. Try to make it seem like I'm wrong. You know what the fuck I'm talking about, bro? Because you did say he snitched, bro. You did say he snitched, bro. Look at the video. Let's go to the video. This is your video right here, yo. This is the one. This is the video I had an issue with.
Now, let's take a look at a recent document filed by Big 30. This was filed April 24th, and it says, as for Mr. Wright's undisputed conduct, basically saying this is something that we cannot dispute that happened.
That's not what they're saying, yo. This is something we're not disputing at this moment. At this moment. Yeah, I ain't say nothing hating, bro. If you watch the whole video, you posted it short, bro. If you watch the whole video, I say, yo, I'm disappointed in Byron, yo. I say I look at Byron as one of the ones that's gonna keep that shit real, bro. I ain't say no hating shit, bro. I ain't say nothing hating. Yo, you used the term where it didn't apply, bro. You used the term when it didn't apply, bro. Look at the examples that they're using. Cross-examination, opening arguments, direct examination. Yo, we talking about a motion for bail reconsideration, bro. Let's go back to the video.
Leaving a bag at another person's request.
Watch your own video.
Filming a document signing.
And look, and you're presenting it like Big 30 is saying all of these things.
Standing at a door.
Listen to what you said.
Undisputed conduct. Basically saying this is something that we cannot dispute that happened. Retrieving a bag at another person's request. Filming a document signing. Standing at a door. The government argues each act individually reflects criminal participation. But these allegations, taken together, describe someone who was present.
Because I could say what they meant, bro. Because we had a bail hearing, bro. We had a bail hearing. We're not going to, it serves no, listen, Byron, this is what you got to understand, bro. The purpose of a bail hearing, right, is to minimize your client's participation. That's the purpose. What the lawyer is doing is using the government's theory against them, yo. That's what he's doing. I'm talking about this scenario right here. He's using the government's theory against them. Let's say we're not going to dispute this. What? We're not going to dispute right now. With you, a judicial admission is a binding statement, my nigga. You made it seem like they are stuck in this. They can't go nowhere else. That's not true. That's not true. That means we're not disputing it. Right now, no. That's not saying we're never going to dispute it. But that's how you presented it, bro. You presented like by saying it was a whatever the fuck, I keep forgetting the judicial admission. That means they are binded by this. I just told you what it means. It means we're not disputing it right now. But you made it seem, but we're not talking. Yo, the most egregious part about it was the judicial admission part, bro. That wasn't a judicial admission, bro. It mean we're not disputing it right now. No, that's not saying we're never going to dispute it. By you using undisputed conduct with judicial admission, you made it seem as though they were stuck in this space, and it like he told, bro. That's what you did. You know that's what you did. And it's like, and instead of just be like, oh yeah, you're right. Maybe I worded it wrong. Yo, you sitting there standing on it, bro. You standing on it. And you wrong, bro. That's all I'm telling you. You sitting there standing on it. And you're wrong. You used the judicial admission part to justify the undisputed conduct, and it didn't fit. It didn't apply. At this hearing, at this hearing. That's not saying that he's never going to dispute it. At this hearing, only part we're disputing is the intent. Hey, Byron, it's not, y'all. I just showed you where the judicial. Yo, that shit damn near a whole hearing, bro. It's damn near a whole hearing, my nigga. Look. Hold up. Where's that part right here? What part of that? Look, in Hanson versus Rugby Construction Company, the plaintiff was the only person who had knowledge of the fall. Like, in order for it to be a judicial admission, yo, it can only be one person present. It can't be no other statements. It can't be no other people present, bro. Because he can't admit that for everybody. It can only be one person. Yo, just admit, yo, you used it wrong, bro. You didn't say he told. Y'all never said you say he told, bro. But I said you allowed the comments to say it, bro. You didn't correct nobody in the comments, bro. You didn't correct anybody in your comments to say, yo, no, he ain't tell. Look, it's definitely telling. You didn't correct nobody, yo. You sitting there, look, they telling. You sitting there, let niggas say, you know what you did, my nigga. You know what you did. It's safe to say they in it. Let's make a deal. Look, you know what you did, yo. Pooh Cook, everybody saving their ass. Everybody snitching. Come on, bro. What you mean you ain't said it? You did, yo. You the one put that shit out there. Now you got a whole nother content creator doing the same shit. Look, y'all. Let's finish reading. See, you making me go back. I already read all of this, bro. Fuck is that? Closing arguments, cross-examination. Looking at the statements made by defense counsel during closing arguments, the court found that the defense. All right, listen to this. Listen to this scenario right here, bro. In Lowe versus Kane, A statement made by defense counsel in the closing arguments was ruled to be a judicial admission. The plaintiff sued the defendant under a negligent theory for injury she sustained as a pedestrian when she was struck by a vehicle driven by the defendant. Defendant denied he was negligent and asserted a comparative negligence defense. During closing arguments, defense counsel repeatedly stated that both parties were at fault and his client should only be found to be 50% at fault. The plaintiff's counsel then moved for a directed verdict on the issue of defendant's liability, asserting that defense counsel had admitted liability on behalf of the client. The court directed a verdict on the issue of defendant's liability based on the statements made by defense counsel in closing arguments. In upholding the trial court directed verdict in favor of the plaintiff, the appellate court reasoned that attorneys, as agents of their client, can make admissions on behalf of their client in all matters relating to the litigation of the case. They're not even litigating the case yet, bro. They're not at litigation stage. We at bail hearing. We're not at litigation stage, bro. The court noted that the fact that statements made by attorneys is made in opening court, closing arguments, or direct examination, or cross-examination. We are so far away from what you just referenced. It's fucking ridiculous, bro. It was egregious, my nigga. Just accept it. You was wrong. And you put out this narrative and allow people to run with it, calling Big 30 a rat, bro. It's relevant to the context in which the statement is made and not determinative of whether or not the statement is a judicial admission. In looking at the statements made by defense counsel during closing arguments, the courts found that defense counsel stated unambiguously that defendant was at fault for causing the accident. And when viewed in the context of the entire closing argument, that the statements were clearly based on the theory and not inadvertently made. Additionally, for statements to be considered a judicial admission, it must be within the knowledge of the deponent. When there are multiple persons with knowledge of a thing, all with conflicting testimony, courts will not hold their statements as judicial admissions. We know that every single one of them. No, it's not, yo. Bond hearing is not litigation, bro. They're not litigating the case in the bond hearing, bro. Litigating is fighting the case, bro. They're not fighting the case right now, bro. They're just trying to get a bond. And that might be, if you want to be technical, you can call it, but you know what I mean. We're not fighting the case right now. We're not fighting the facts right now. Not all of them. It's not time for that. It must be within the knowledge of the deponent. When there are multiple persons with knowledge of a thing, all with conflicting testimony, courts will not hold their statements as judicial admissions. However, when a party makes a statement about a matter that only they knew about, courts have held those statements to be binding judicial admissions. That's why what I said to you, I say, yo, so basically what you're saying is they stuck in these statements. You're like, well, I ain't saying that. The lawyer said it. No, yo, you saying that by saying it was a judicial admission. You saying you saying that when basically what you told your people was when they go to court, they're not gonna, if they was to say, yo, basically what you told your people, when they go to court, if Big 30 was to say, I ain't hand him no bag, they'd be able to go back to the bail hearing and say, look, your lawyer said that you did hand him a bag. Yo, that's not how that go, bro. That's not how that go, bro. It's undisputed at this moment. That's all that was. At this moment, we're not disputing that. We need that right now. That's all I'm saying. Right now, it serves us a purpose to say he handed him a bag. He stood in front of the door. He recorded it. Yeah, we need that because you know why? Because that's not violent. That's not violent. technically, I said technically is litigation. But you know what I mean. We're not, litigation is fighting the case. Litigation is fighting the case. You know what litigation is. Right now, we're at bail. We're dealing with bail, yo. The judge will tell you, if you was to go too deep into the evidence at a bail hearing, yo, the judge will stop you, bro. The judge will stop you, bro. You know what I mean, man? Like you trying to play words. Just admit you was wrong. God damn, my nigga. Like, if I'm wrong, yo, I say I'm wrong, bro. That's why I said we'll see at trial. Because if you right, Big 30 is gonna go. Big 30 lawyer is gonna go in there and say, yes, my client handed him a bag. Yes, my client recorded it. Yes, my client stood at the door. No, they're not gonna use it, bro. Not at a bail hearing, yo. Not at a bail hearing, bro. Not at a bail. No. You gotta remember, it's binding, Byron. It's a binding statement, which means they can't back away from it. It's binding. You know what binding mean, right? That means come trial time, Big 30 lawyer is gonna go in there and say, yeah, my client handed Pooh Shiesty a bag. Yeah, my client stood in front of the door. Yeah, my client recorded it. That's what you're saying, y'all. Yo, I wish I had my motherfucking paperwork. I wish I had. Yo, I'm gonna look through this paperwork right here, right? And I'm gonna see if I got my motion for bail. I'm gonna go through all this paperwork one of these days soon. And I'm gonna see, because I might got it, might be in here. Matter of fact, where the table of contacts at? That's in this bitch some motherfucking way. It might be in here. Cause this is my discovery packet right here, bro. Right here is my discovery packet. And I might have my motion for bail reconsideration in this bitch. And I wasn't gonna go to court to admit to nothing. The fuck, like, that wasn't like, yo, at a bail hearing. No, he didn't say all that was undisputed conduct. What he disputing? Look, right now, what he's disputing is the intent. Because in order to secure a bond, yo, you gotta remember, yo, you're not, the part that you forgetting, yo, is that this is a bond hearing, bro. This is a bond hearing. So my job is to minimize my client's role. Probably wrong, yo. Like, there's nothing I'm saying delusional. My client is to, my job is to minimize my client's role, bro. Is that not his job right now? Exactly. But that's just for this hearing. You said it was a judicial admission, bro. It's not. That's what I'm saying. It's not a judicial admission. Because that's binding. But you said it's a judicial admission, yo. That's the part you're forgetting, yo. That's the egregious part of it. That's the egregious part. It's not a judicial admission, bro. That's where you're wrong at. By saying that's a judicial admission, yo, you're saying that man's telling, bro. It's not, yo. I just showed you what a judicial, yo. No, I can't, Byron, you wrong, yo. You're not. I just showed you what it was. Do we gotta continue reading? Yo, instead of just admitting you got it wrong. No, it's not, yo. No, it's not. It has to be recognized. Like, that's damn near a whole hearing, bro. That's damn near a whole hearing. That's damn near a whole hearing, yo. In affirmative courts, ruling on a motion for summary judgment, the appellate court stated that the plaintiff repeated statements throughout his deposition that the rubber bumpers were the cause of the accident were unequivocal and therefore amounted to a judicial admission. The court further reasoned that the plaintiff's testimony about the rubber, like, yo, Byron, you wrong, bro. The government didn't already say anything, bro. It's not the government. The judge has to rule on it, bro. The judge has to rule on it, bro. Not the government, my nigga. Judicial admissions is recognized by the judge, bro. Yo, that's a high bar, yo. Like, that's what you're not understanding, bro. That is a high bar. Byron, you wrong, yo. I'm not gonna keep going. Yo, I know you wrong, but I know you stubborn. You know, I done dealt with your stubbornness before. I know you stubborn, bro. I get it. You know what I mean? I get it, yo. But yo, that's not solid, my nigga. That ain't solid, bro. If you wrong, my nigga. Because the judge has the final ruling on everything, bro. The judge, I was trying to come out. I told him we can go live about it. He wanted to get disrespectful. He wanted to get disrespectful. I ain't going on you, yo, threatening to fight you and shit like that. That's goofball shit, bro. It's goofy shit, my nigga. I don't operate like that, my nigga. So if the judge wasn't there, how is he making a judicial admission, bro? If the judge wasn't there, how is he making a judicial admission? What we just read, let me finish reading this, then we're going to go back to your video. Once a statement of fact has been ruled, look at this word, bro. Once a statement of fact has been ruled a judicial admission, I'm just gonna leave that there, y'all. I don't think they didn't even go to court yet. Exactly. So how's you calling it a judicial admission when they ain't even go to court, bro? Now you starting to come around and see that you don't make sense. Because it's, yo, come on now. You know, so come on, Byron. You ain't gonna do that. You know the judge has to rule on everything. You can't just get together with the motherfucking the government and come up with a court date and then have a court date. You gotta run it by the judge, bro. The judge gotta confirm it, bro. Everything has to be confirmed by the judge, Byron. See, that's what I'm saying. You're not making sense, y'all. You're not making sense. And that's what happens. That's what happens when you start just talking, bro. I don't need to look it up. Yo, but it still has to be ruled on. It still has to be a ruling. Yeah, I said damn near has to be a whole hearing. But it has to be ruled on. It is binding on the party that made the statement. That courts have frequently stated that the purpose for judicial admissions is to eliminate the temptation of a party to commit perjury. As such, a party cannot introduce a contradictory statement in order to create a factual dispute, including but not limited to an affidavit from the party who made the statement. Listen, they talking about affidavits and shit, bro. I'm just saying you use it in wrong context, y'all. I'm not saying judicial admissions aren't a thing. I'm just saying it don't apply for that hearing that you did the video on. That's all I'm saying, bro. That's that, like, and you want to go back and forth with me and argue, and you're wrong, y'all. I'm showing you wrong. If them same people was on that live, no, but it still has to be ruled upon. It still has to be ruled upon, y'all. It has to be ruled on, which means in open court. If this is said, like, they didn't even have a hearing for this yet, bro. Like, yo, that was a motion. They didn't even have the bail hearing yet. Yo, we reading it, yo. Because that can be misleading, yo. So I'm not going to look it up just so it could be misleading, yo, because we're talking about applying it here. It doesn't apply for this situation. It doesn't apply. After a statement has been made, has been determined to be a judicial admission, other facts that necessarily come from that statement can also be determined a judicial admission. All right, so, all right, look, you see that? Look at this part. No, it don't. Look at this part, Byron. After a statement has been determined to be a judicial admission, other facts that necessarily come from that statement can also be determined a judicial admission. So, is this a judicial admission too? So if we're going to say, listen, Byron, Mr. Wright, undisputed conduct, retrieving the bag at another person's request, filming a document signing, and standing at a door. These are all judicial admissions, right? Right? So is this a judicial admission too? Not someone who orchestrated or escalated the incident? Well, this is undisputed conduct. So is this undisputed conduct too? You're saying that this undisputed conduct is a judicial admission, bro. So based off what we just read, you have to say this is too. You can't just stop it right here because that's not what a judicial admission is. Look. And why the fuck that should always take me? Look, after a statement has been determined to be a judicial admission, other facts that necessarily come from that statement can also be a judicial admission. So based off of that law, that whole statement have to be a judicial admission. Exactly. You're right. But you're right. I agree. But that's not what this is. That's all I'm saying, yo. That's not what this is. It's not what this is. Yeah, he might have used the word. You understand? But that's not what this is, man. We're not disputing this right now. Nah, Byron, you wrong, bro. You wrong, yo. No, I'm not. I know exactly what I'm talking about, yo. But we're not disputing right now. These are it's undisputed. Yo, I hope this get enough publicity to where if his lawyer do an interview, he talk about it. Yeah, that's all I'm saying, Ron. Like you making this is a bond hearing, bro. This is a bond hearing, bro. Yo, we looked at the examples: closing arguments, opening arguments, evidentiary hearings. Yo, that is when judicial admissions are made. Just because he used the word undisputed conduct, that don't mean he's making a judicial admission right here, bro. I need to get to the. So let me run your video. You see what you said.
Compliant with instructions, not someone who orchestrated or escalated the incident.
You said
the individual who died.
You're right. It can happen at any time, but what's the likelihood? that is happening now at a bond hearing. That's the part you're forgetting. What's the likelihood that a lawyer will admit to something at a bond hearing? That's not what he did, y'all. No, Byron. You can't say fuck likelihood. That's what life is about. Probability, chance, likely. That's what life is. It's like rolling the dice. That's what life is about, bro. It's about likelihood, bro. It's not likely he's not talking. He's not doing that right now. He just used that because it makes sense to use. It makes sense to use. Because it shows that his client didn't do anything violent. It is. Everything's about likelihood, bro. What are you talking about? It shows that his client didn't do anything violent. That's what it shows. If we running with the government's theory that he did all of these things, why he not getting no bond? And we concede. At this hearing, we're going to concede that he did get the bag. He did stand in front of the door. But it's not because he was a part of the criminal act. He was just acting on behalf of another person. Yo, he's trying to minimize his client's role, bro. That's all he's doing. He's not snitching, my nigga. Yeah, he's trying to get a bond. That's what this whole paperwork is. And Byron, that's the part Byron didn't even explain that. In this hearing. He's not snitching. Like but you presented like he testified, y'all. Byron, you know what you did, bro. Let me finish playing your video. I'll talk to you when we ain't get to the next video yet.
Directed that a firearm be produced was Lontrell Williams Jr. The individual who pointed a firearm at RD's head was Lontrell Williams Jr. The individual who
Yes, the fuck you can, bro. What are you talking about? You can't admit it in one hearing and deny it in the next, bro. When you talking about a bond hearing, you can't do that at an evidentiary hearing. We watched a Chicago. Did we not witness this? We watched Dirk and King Von get arrested. And at their bond hearing, what the detective said? What that detective said at King Von and Dirk bond hearing, bro? You remember? I'm sure you remember. You covered it. What did the detective say at King Von bond hearing? You see him shooting out the window. Oh my God. No. Byron, you wildin', bro. Just admit you wrong, my nigga.
Victims of jewelry was Lontrell Williams Jr. Mr. Wright is not charged with being Pooh Shiesty's equal in this alleged kidnapping robbery. Y'all see the point. Y'all see.
All right. I say you right with that. So that may be. You're right. Your detective can make a judicial admission. But what you said, I was talking about when you said that you can't say one thing at a hearing and switch it up at another one. Now we're going back to a judicial admission part. All right. He can make a judicial admission, but that's not what you said. You said you can't say one thing at one hearing and then say something else at another. You can. They do it all the time. Yo, this is a bond hearing, bro. They're not fighting the case right now, my nigga. They're not fighting the case right now, bro. Like, there's no need. We're not going to fight all the facts. What? That's not a good example, y'all. Who's going to claim self-defense and then come off of it? That was a bad example, just like I used a bad example.
Where this is going. So this is Big 30's lawyer, basically saying, again, undisputed conduct means, we not disputing this at all. We not refuting this. Just like his father disputes that he was present in the room, Big 30 is not disputing that. He's not arguing that he wasn't there. He's saying, hey, I was.
Well, we already know that you can't make a judicial admission when it's multiple people giving different accounts of the situation. So that takes the judicial admission part out of it right there. Look, additionally, for a statement to be considered a judicial admission, it must be within the knowledge of the opponent, where there are multiple persons with knowledge of a thing, all with conflicting testimony. Court will not hold their statements as judicial admissions. So that ruins your whole argument right there, bro. Where there are multiple persons with knowledge of a thing, all with conflicting testimonies, court will not hold their statements as judicial admissions. They're not on opposing sides, bro. We talking about the defendants. It said it must be within the knowledge of the deponent. But this is something different right here. When this sentence has nothing to do with this sentence. When there are that's the end of this. This point ends at the question at the period. This is a new sentence. When there are multiple persons with knowledge of a thing, with all conflicting testimonies, court will not hold their statements as judicial admissions. All right, so listen, Byron. Let's use your example. The government is saying that Big 30 was a full participant. These opposing sides now, we're using your argument, so it shouldn't be no pushback from this. The government is saying that Big 30 was a part of it. The defense is saying that, no, he wasn't. He was just present and complying with instructions. So does that fit your narrative? These are two opposing sides. They're disagreeing. Like, you can't just use this statement without the rest of them.
I did retrieve the bag. I did film the document signing, and I did stand at the door. But I was doing this because I was compliant with the instructions that I was given, and not because.
But we also know, because we read it, that you can't just take this part of it and not this part of it. We read that on a judicial admission, it has to be the whole narrative. Do we gotta go back to that part? I read it to you, I'm sure, a few times. You can't just say this is judicial admission and not say this isn't either. You can't do that. We just read it. So you're gonna continue arguing, or you understand? Oh my God, Byron, whatever, bro.
Because I was participating in something that we had planned out. Long story short, this case is a mess. You got one person denying he was there. You got the other person.
Let's go back to it again. We all heard it, y'all. Look, after a statement has been determined to be a judicial admission, other facts that necessarily come from that statement can also be determined to be judicial admissions. So I read it to you now. So you can't say one is a judicial admission and the other one isn't. And it has to be determined. It has to be ruled on, yo. This haven't been ruled on, bro. This haven't even went to court yet. They haven't even had the hearing yet, bro.
Person admitting he was there, but basically saying he was just doing what the other people, what the main co-defendant asked him to do, which is now
but the government doesn't agree with that. But in order for it to be a judicial admission, both sides have to agree. The government doesn't agree with that. The government is saying he was a full participant. No, Big 30 wants a bail, man. This ain't about time. No, the government disagrees with this part. The government, but these allegations taken together describe someone who was present and complied with instructions. This is the defense theory. The government's theory is someone who orchestrated or escalated the incident. Yo, but you gotta be, it's either all or nothing, bro. Based off of what we know a judicial admission is, it can't just take part of it.
Shiesty did ask him to produce a bag, and that he did produce the bag, and that there were weapons produced and used to rob these people. Now, you got a lot of guys who will say this is just the attorneys arguing in defense of their client. They have a right to defend their client. None of this can be used as evidence against anybody. And people are right to a degree in that sense. But this is why I always take the stance that this is hurtful. And this lawyer, this very professional, highly paid attorney withdrawing from this case is evidence of it. Let me show you. No, it's not.
See, then look what you did. You tied the fact that Brad Cohen left the case to this. That's another thing you did, bro. Like how did you make that connection, bro? It's always better to go with an attorney that's from that town, that's from that city, that's from that state. Byron, you know what you did, bro. Don't act like you don't know what you did, my nigga. Yeah, but you know what you did, y'all. You alluded to the evidence being stacked. Yo, this is what you did, since you don't want to admit it. You used these documents to try to show that, look, everybody's putting the blame on Pooh Shiesty. Which then, in turn, Brad Cohen to remove himself from the case because it's unbeatable. That's what you did, bro. You know it. Like, come on, don't sit there and act like you didn't. Come on, man. Everybody that watched it. Yo, but they're not blaming anybody because we're not even at that point in the case yet. Nobody's blaming nobody right now. Nobody's blaming anybody right now, bro. We had a bail hearing, my nigga. We just trying to get out. The fuck? Yeah, JB was tripping. Yo, niggas told you want to fight and shit. Like, what the fuck wrong with you, bro? Like, god damn, I ain't trying to fight you, yo. I still respect what you do, yo. You just wrong right here. Like, yo, you're not gonna get me emotional. Like, I'm a, you know what I mean? I don't operate like that, my nigga. You feel me? Yes. In order to convince the judge that, yo, my client deserves a bond. He's not a criminal. He didn't go there with intent to take anything. Look, you still being disrespectful. Yo, ain't nothing to suck about me, bro. No, it's not on the record he's admitting anything, yo. He's not on the record admitting anything, my nigga. He just trying to get his client a bond, yo. They can back away from this at any moment. A judicial admission, they can't, they binded by this. They're binded by this based off of the video you put out. Byron, come on, man.
What you just read and what you just heard from
Look.
McThirty's attorney is called a judicial admission, which is a formal, deliberate, and unequivocal statement of fact made by a party or their attorney
Look.
during judicial proceedings, such as in pleadings, like motions, stipulations, or open court that binds the party,
Look.
removing the need for proof regarding that.
So basically what you said, that the government don't even have to prove that. So based off of your video, the government is not going to have to prove that big 30-handed Pooh Shiesty to Drake. No, I'm asking you a direct question, bro. It's undeniable. It's not going to have to be proven. No, they're not going to use it against them, man. That's all they doing, JB. That's all they doing. I think 30 is just trying to undermine the Fed's theory. That's it, yo. That's it, and that's all. Nothing else to see here. There's nothing else to see here, bro. That's all I'm telling you, yo. You need to upload a video and just get it right, bro. People look to you just like they look to me to get valuable information, yo. Because your knowledge of law, just like my knowledge of law, is better than most based off what we've been through. But by you doing this video, basically alluding to the man is telling, yo, you was dead wrong for that, bro. You was dead wrong for that, my nigga. Like it ain't no. See, look at what you. I'm trying to ride your wave, Byron, yo. I'm trying to ride your wave. I'm trying to ride your wave. The nigga that been sharing your videos for 2 years. Just think about what you just said, because you said that before. The nigga that been sharing your videos for 2 years before 1090 Jake exposed is trying to ride your wave. Like, you sound crazy, bro. Have I or have I not been sharing your videos before anybody else? Am I making that up? When you was at 17,000 subscribers. No, yo, that's we being real. Cause you sound riding your wave. And I was in my 20s. Was I not sharing your videos, yo? Was I not putting people on with your channel? For you to say I'm riding your wave. You just talking, bro. You just talking, bro. You speaking out of emotion, my nigga. No, yo, you was wrong, yo. I wasn't even saying your name, my nigga. I wasn't even saying your name, bro. I wasn't saying your name for a reason, man. Yeah, yo, yeah, you losing it, shorty. You forgetting. You forgetting. Based off your comments, y'all 38 people, I got thousands of subs. Yo, I probably done sent a few hundred over that bitch. I got a nigga in my comments right now say, yo, thanks, yo, for putting me on with Byron Blake. He didn't say he snitched. He alluded to it. That's enough. The same thing he accuses all the rest of these niggas of doing. He did it. The same shit you accuse. It don't matter, bro. Hey, Byron, come on. That's the type of nigga you is, bro. It don't matter if I sent one person there, my nigga. That's how you operate? Instead of just be like, yo, yeah, you right. You have been sharing my shit for a long ass time. You gonna sit there and act like that? That ain't no real nigga shit, bro. That ain't real, my nigga.
Fact. These admissions cannot be contradicted later, even on appeal, and it breaks down how these are binding.
Only reason my videos slowed up is I stopped doing uploads and I started working, my nigga. And your page wasn't moving faster than mine, my nigga. I was getting 1,500 subscribers a month, my nigga. Well, all I gotta do is get back to it. The fuck, I just ain't been doing it because I work like a motherfucker.
It gives you other characteristics of a judicial admission and the effect that it has on the case.
His lawyer didn't do anything. Like, yo, that's what I'm saying. You making this? His lawyer didn't do anything, yo. Yo, come on, yo. Don't be disrespecting my people, yo. I ain't disrespecting nobody over there, yo. Hey, Bob, you coming off as real emotional, bro.
Thing is, once you say this, it's considered locked in as a fact. You cannot present evidence that contradicts this, or this statement right here, this judicial admission can be brought in.
Look at what you're doing. What you mean, yo? Everything you saying he snitched, bro. Listen to what you just said. You must don't know what you said. Listen to what you just said again.
How these are binding, it gives you other characteristics of a judicial admission and the effect that it has on the case. But the most important thing is, once you say this, it's considered locked in as a fact. You cannot present evidence that contradicts this, or this statement right here, this judicial admission can be brought in to impeach you. Now,
dude, these are your words, not mine, my nigga. Yeah, you jumping around from undisputed. You confusing yourself. You keep zeroing in on that word and using that word to define judicial admission. And that's where you're wrong at, bro. That's where you're wrong at. No, it don't. Not in this case. Not in this case, bro. Not right now. Maybe if this was an evidentiary hearing, you would be correct. If this was a motion in limine, you would be correct. If this was opening statements, you would be correct. If this was closing arguments, you would be correct. But not at a bond hearing, yo. Not at a bond hearing, my nigga. That's all I'm telling you, yo. Not at a bond hearing. Well, they don't even, like I told you on your live, they don't even got discovery, my nigga. He did remain silent. See, look, this is somebody that follows you. Listen, look at what they saying. He should have remained silent. For all we know, he did remain silent. I'm saying it's not likely, bro. It's not smart. It doesn't make sense. A lot of people follow Byron Big because of me, man. I don't know why you sitting over this bitch playing great. Like, yo, you coming off is flawed, bro. Like, yo, I ain't come at you like this, my nigga. Even when we was going back and forth, nigga, I wasn't over that bitch getting all emotional with you and leaning, cussing out the people that follow you. And like, yo, what are you, like, yo, you out here looking wild, shorty? Like, for real, my nigga. Like, I don't know what you think. Like, yo, you looking crazy, bro. Like, for real, yo. Like, you looking real flawed, yo. Like, you want, I mean, like, the emotional ass nigga. Yeah, D, but you watch him and God, no, cloud chase. All right, Bob. I'm just saying you wrong. Like it is what it is. So like I showed you was wrong. I'm explaining to you how you wrong, and instead of you just admitting you was wrong, instead of yeah, I know I was right. Byron wrong. I don't know why he just not gonna admit it. Instead of you admitting you wrong, you just trying to stand on it, bro. That's not real nigga shit, bro. I showed you where you was wrong. I explained to you how you wrong. Like I said, if this was closing arguments, you would be right, bro. Yo, they haven't even had a hearing yet. They didn't even have a hearing yet, bro. They didn't even have a hearing yet, Byron. They didn't even have the bail hearing. Like you sitting there saying it, yo, this is like, oh, they didn't even have a hearing yet, my nigga. Like, yo, you're not making sense, bro. Yeah, come on, that's what I'm saying, how bro. Like everybody over here know I've been supporting this nigga. You over this bitch called talking about I'm clout chasing and trying to ride your wave. Like nigga, I'm probably one of the ones to help you create a fucking wave, my nigga. Yo, the difference between closing arguments is we are at the advanced stage of the case. We already have discovery. We know what we got. We know what we don't got. Yo, they don't know anything right now, bro. And you over this bitch saying they made a judicial admission, man. Like, yo, this bitch saying they made a binding. Fuck, we ain't even gonna call it a judicial admission. Let's call it a binding statement. That all throughout these proceedings, they're gonna have to stand on this on this theory. Yo, that's wrong, bro. That's wrong, bro. And you know that's wrong, my nigga. We ain't had not one major motion. We ain't had no motion to suppress. Like, yo, we ain't have nothing, yo. We ain't have no motherfucking scheduling conference. We didn't have nothing. And you over this bitch, they didn't even have the court date for this yet. And you over this bitch talk about this is a judicial admission, bro. And you don't see where you wrong at. For the most part, yeah. 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 There is. Nobody's going to bind themselves in a statement they didn't even have a preliminary. Like, yo, that's what I'm trying to show. They didn't even have a fucking preliminary hearing, my nigga. They didn't have an arraignment. And you over this bitch talk about he made a judicial admission, yo. I'm gonna finish playing the video. Cause you just not gonna admit it.
I want to go back to this Big 30's attorney saying that Big 30's undisputed conduct is that he retrieved a bag at another person's request, filmed a document signing, and stood at a door. By all legal rules and standards, yes, stating in a formal motion, which was what you just read, that your presence at a scene is undisputed conduct is likely a judicial admission. So, all of that stuff you just heard and read, he was there at the scene, he stood at the door, he retrieved a bag at Shiesty's request. All of those things are judicial admissions. Big 30 is now locked in to that theory. He can't come in now. If he comes in now and says, hey, I never stood at the door, then the government can bring up what was said in this motion to impeach him. And it's the same with Shiesty's attorney. I mean, with Shiesty's father, and him saying that he wasn't at the scene. He's now trying to argue that he wasn't. He disputing being at the scene. So if he come back now and say, "Yeah, I was there," then it's just a big mess. Long story short, and the attorney that Shiesty had on his case, he don't want to have, because what do you do now? What is your argument when you got your client's right hand man?
Look,
basically, and
look at, so you're not saying he telling. Listen to everything you saying, yo. What is his argument now? Know what Pooh Shiesty's argument is? This shit ain't never happened. It ain't no statement on paper, D. That's what I'm trying to give people. That's what I'm trying to get people to understand. He made it seem like this nigga told, man. And you made it seem like he told. But you sitting here trying to argue with me like that's not what you did. That's exactly what you did. That's why motherfuckers is confused. So where's the statement? Like, nigga ain't say or he ain't tell, man. His lawyer didn't make no judicial admission. They're not bound by this theory because it's too early in the case, man. Yo, he can't deny being there, bro. How he gonna deny being there? Can't deny being there? What are you talking about, bro? I'm good. How is he gonna deny being there, my nigga? There's no way he can deny being there. Let me see. Y'all send that shit to my phone. Let me see something. I bet he denied being there. I bet he denied being there to the police. I bet he denied being there to the police. That's what a snitch is, bro, and what's not. Did he tell the police he was there? Now, if he told the police he was there, oh yeah, that nigga told. If he told the police he was there, he told. If you can't, how is he gonna deny being there, my nigga? The nigga can't deny being there, bro. They got the nigga on motherfucking camera, my nigga. Nigga can't deny being there, y'all. Not speculating anything. It's Big 30 right here. Oh, that's not him. There's Waters. They got all these niggas on camera, man. They can't deny being there, bro. How are you gonna do that? No, man. That's what I'm saying. Don't be sleep. No, Big 30 lawyer is Big 30 lawyer is using the government's theory against them, y'all. The Big 30 lawyer is trying to get it. So we gotta get this established. He's trying to get his son not his son. He's trying to get his client a bond. Right? At the early stages of their investigation, they don't have discovery yet. Yo, you know how long? Look, let me show y'all something. Yo, this is my discovery right here. Yo, do you know how long it takes to get a packet like this? Like, how long? Yo, they've been locked up for a month. Do you think they got this? Right here. This is fucking probably 500 pages or more. 574. It's like 600 pages. This is the discovery right here. This is my discovery, not theirs. So they don't have this yet. It takes months. It takes months to get this. You understand what I'm saying? So all they got right now, what they think I was supposed to leave it. You did, but you did leave the door open. So look, so at this point, all they have, man, we talking about what we see. All they have, come on, Bob. You know they ain't got no discovery. You know they ain't got no discovery. At a bond hearing, you ain't got no discovery. The lawyers just started working on the case. So the fucking government probably didn't put the discovery together yet to even hand it over. So what I was saying, somebody that asked, who the fuck said that? Don't be sleep. All they have is the government's theory. That's it. The government's theory on Big 30 is that he stood in front. God, fucking he stood in front of the door. He handed Pooh Shiesty a bag. The government said it contained the Drake. The defense is just saying he handed him a bag. And he recorded the incident. So I'm trying to get my client a bond. Based off of that information, undisputed. We're not going to dispute this right now. Based off of that information, what did my client do that was violent? Because bond is determined by role in the crime, risk to public safety, severity of the offense. So if all y'all saying is that my client sat in front of the door, gave Pooh Shiesty a bag, and recorded it, and y'all saying that Pooh Shiesty robbed Gucci Mane, pulled the Drake out, pulled out a Draco, and all of that, why is it that my client ain't getting the bond? That's it, y'all. That's it and that's all. And that's not telling, man. It's not telling. He's not saying no, y'all. He's not. When it say, it doesn't say my client handed Pooh Shiesty. Did it say we're not denying that my client handed Pooh Shiesty a bag with a Draco in it? Did he say that? Did he say it was undisputed that my client handed Pooh Shiesty a bag with a Draco in it? Or he just said a bag? Because the government's saying it was a Draco in it. Did he just say a bag? Or did he say a bag with a Draco? Come on, bro. You know what's going on, man. I don't even know why you played this game with me, man. I don't even know why you even do that, bro.
Admitting that everything happened, just saying I ain't the one that did it.
Look.
And
retrieving a bag. He ain't say nothing about no Draco. Just a bag. A bag. But is that a crime? Is handing Pooh Shiesty a bag a crime? He ain't say a bag with a Draco in it. He just said a bag. But I think you making a fool of yourself, shorty. For real.
Um, you got to blame Shiesty for this because this is the standard that he set for his guys. This is how they played the Florida case. I just talked
Exactly,
about this
JB.
in the last video. I just told y'all, just by Hernandez Govan saying that Shiesty and his team was calling trying to give the jury back, that let it be known it was some funk amongst them about taking that jury. So I kind of saw this coming, but it is what it is. It's right here in black and white now. They locking themselves into different theories, and it looked like they playing an every man for himself type of angle, and that leaves Shiesty with no.
Yo, you just said they locked themselves in to different 30s. They didn't lock themselves into anything. They didn't lock themselves into anything, bro. He's not locking himself into a theory. He used the government's theory. That's all he did. I already made one. I made one. That's all he did. They're using the government's theory to show how minimal, if the crime occurred, like the government said, so we're not disputing that, because the government said a crime occurred, so we're not going to dispute that. If the crime did occur, yeah, it's undisputed. I'm using your words. It's undisputed. All my client did was give him a bag, stand at a door, and film a document signing. It don't say he filmed this signing under duress. It don't say he stood at the door to block other people from witnessing it. It don't say he stood at the door to stop Gucci Mane from running out. It don't say none of that. That means it's undisputed at this time, y'all. Yeah, at this time it is undisputed. At this time it is undisputed. No, Akeem. Yo, we talking about a bond hearing, man. Like, what did y'all? Are we talking about a bond hearing? This is not a motion to suppress. This is not an evidentiary hearing. This ain't. They didn't even have a hearing yet. Yo, 30. I don't think 30 saying it. 30 didn't say a robbery happened. Did 30 say a robbery happened? Look, read it again. 30 said, not 30. 30 lawyer said he gave a bag of another person's request, filmed a document signing, and stand at a door. The government said that Lantrell Williams Jr., the individual who stripped victims of jewelry, Lantrell Williams Jr., pointed a firearm at RD's head. That's what's going on right here, bro. It's like you mixing all of this together to trying to make it one. This is two separate, different. This is one argument. This is a different argument. Who the hell told you that, I came? Ain't no bond hearing. He was told anything. He didn't say anything. Byron. No, Byron. You didn't say a robbery. You didn't say a robbery happened. You didn't call Pooh Shiesty a snitch. Yo, but the way you presented this story, you presented it like he told. You said that he's locked in to a story. That's what you did, bro. Like, oh, I'm not gonna sit back. You know what you did, my nigga. I didn't dispute that. Yo, I know it's undisputed at this time because he ain't have to say it. It's a bond hearing, bro. It's a bond hearing. We're not here to dispute things right now. Now let's go to the video you made about me. Like yo, if I was to go to my motherfucking hype, you know who videos I hype the most on this bitch? Byron Blake, urban politicians. And this nigga over this bitch try to make it seem like I'm a hater. Nigga, I be the one hyping your motherfucking videos, nigga. Like, you wrong for that, bro. You wrong for how you came at me, my nigga. I can show you that shit. It show. Do you hype my videos?
See exactly.
Because I hype yours, my nigga. Talking about I'm a hater and I'm clout chasing.
So I made a video breaking down why I believe Pooh Shiesty's attorney quit. In this video, I cited a couple of things that...
Yo, you know it's at this time. Shiesty, you don't have to say at this time. You know it's at this time because it's a bond hearing, bro. Man, big bro, what it is? It's a bond hearing. They not get nobody's locking in at a story at no bond hearing, bro. Like, that's not how that go, yo. You ain't never had a bond hearing before? Not the first one, but a one that your lawyer got to file. A habeas corpus. Have you ever had a habeas corpus before? I know that is crazy, yo. He said I was riding his wave. Nigga, I helped contribute to your wave, bro. Way before that motherfucker left the shore, my nigga. That's why I said we're going to see come trial time. Because based off of... That's why I said we're going to... On your page, I said we're going to see come trial time. Because basically, with the video you ran, you said they're stuck in this story. Okay, that's what judicial admissions mean. That means they're stuck in this story. So we're going to see come trial time if they're stuck in the story or not. Or do they have a whole different narrative? That's what we're going to see. And then that's why we're going to know who's right and who's wrong. But based off of what I just read, he ain't commit no crimes. He didn't hand Pooh Shiesty a bag that contained the Drake. He didn't film a document signing under duress. And he didn't stand in front of a door to prevent another person from leaving out. Because you heard what I just said? He can't say he wasn't there. That's what I'm saying, yo. He can't say he wasn't there. But what he can say is, I didn't witness no robbery. So look, let me show you how this go. All right, let's run with the narrative that Big 30 lawyer just put out there, right? I handed him a bag. I filmed the document signing, and I was standing at the door. Let Pooh Shiesty say, yeah, I never robbed him. I was there. I was there to to get out my contract. Though that line and Big 30 was there just to record it, so he wouldn't try to say that it didn't happen. What if that happened? Would that still be snitching? What if they all running with this narrative? What if they all running with this narrative? No, that's not an agree to disagree type situation, yo, because you got the internet thinking this man is snitch, man. That's wrong, bro. That's the same shit you accused whacking them of doing, yo. That's the same shit, yo. You basically did the same shit that you accused whacking them of doing, bro. You just don't realize you did it. Go to your comments. Like, you sitting there asking me where did you say he snitched at, but go to your comments, bro. You ain't correct nobody in your comments. Byron, you didn't correct nobody in your comments. Did you correct? Did you correct anybody in your comments when they called him a rat? You know how influential blogs is, bro. You know you got influence. Just like I got influence. I mean, you know what you say, people repeat. Or what you put out. Yeah, but I'm not saying that he's binded in it. You're saying that he's binding. You say he binded with that statement. I'm not saying that. I don't think he is. Because I don't think that's even a statement. I think he just used the government narrative to secure a bond for his client. Yo, you didn't, Byron. Coming off like a bot, bro. Did you correct anybody in your comments that called him a rat? Is the question.
His father's lawyer argued at court, and a couple of things that Big 30's lawyer argued in court. While I was presenting this, I was giving y'all a legal breakdown of what some of these terms mean. The thing is, a lot of these guys will discuss cases with you, and they'll think that because they caught a case before, that means they know how the legal system works and all of that. But a lot of these guys, they look at these documents and they have no idea what the words mean that they are reading. They can read the words, but they don't have a clue what the words mean. And so it shows you how a lot of times guys go into court and don't even realize what's happening to them, because the lawyer is saying stuff and you only picking up certain parts and you just like, oh, that's what he means. But in reality though, it's something totally different. Now, when I made this video, blogger Keep It G News, which is actually somebody that I think is pretty cool. You know, we don't agree on everything, but I'm perfectly fine with agreeing to disagree. What I don't like is, you know, the videos where you clearly discuss.
Let me show you something
what
too,
I'm
bro.
Talking about
that video you showed. I wasn't even talking about you, bro. I was talking about this nigga. Did I say that shit? Because when I was talking about you, I mentioned you. The fuck the nigga name that be covering the federal paperwork on Instagram? The fuck is your name? Yo, do y'all know the dude? I might can find him. Montana Burnett. Because he covered Montana Burnett before. Montana. Shit. Damn. Fuck is that nigga name? He got like a little funny voice. Little brown skin dude. Light brown skin dude. Y'all know what I'm talking about? Little brown skin dude that be covering the cases. And this is, oh, I was just ready to say that too. This is not, yo, I meant to say this too. They did not deny Melly's bond either. It got deferred for a later date. Byron got me off track. When I was going live, that's what I was going to talk about. So I clicked on my phone and see this nigga fucking did a video of me and shit. And what's the little dude with the yeah, so Melly Bond didn't get denied. It got deferred. He got a funny voice. And he be talking about, yeah, this is the top hitters in each state. And he be doing shit like that. Little brown skin dude. No, because I was showing you. I wasn't talking about you in that clip. I was trying to show you who I was talking about. I can't find it. Let's get back to this. You see, yeah.
But instead of just saying my name and hey, this is what's going on, you do like some passive aggressive stuff. And at the same time, it's clearly an attempt to discredit me. And the truth is, you are the person that's wrong. So,
yo, let me show you what I said. Cause you ain't even go to the right video. I was very respectful in what I said about you. I was hurt. I'm like, damn, yo, Byron, why the fuck would you do that, bro? Like, I look at you on the internet like a nigga like me. Yeah, man, nigga that's gonna keep that shit real, man. Nigga that's fighting against the fuck boys. So when you did that, yeah, it's the same video. You ain't show that part. When you did that, I'm like, damn, yo, what the fuck is up with Byron? What the fuck kind of shit he on? So if the indictment says that, yo, you was dead wrong for that video, bro. Here you go, right here. See, now I'm coming from North for sales. You said I ain't say your name.
I'll see you there.
All right.
Okay.
Wrong for that video, bro. Y'all, I can't believe Byron Blake did that. I'm upset with Joe about that, man. I still rock with him. He's still one of the more solid niggas on the internet, yo. But yo, that's what I say about you, bro. That's what I say about you, bro. You ain't play that part though. You man, I ain't slander you, my nigga. You was dead wrong for that video, bro. How I sneak this and I said your name? Yo. That video was I said your name on the internet, yo. But yo, you was dead wrong for that video. Yo, like yo, I can't believe Byron Blake did that. I'm upset with Joe about that, man. I still rock with him. He's still one of the more solid niggas on the internet, yo. But yo, you was dead wrong for that video, bro. You was dead wrong for that video, yo. That video was, yo, you seriously mischaracterized that paperwork. And now you got niggas copying it, following it. Look, shaking my head. That's disappointment, my nigga. I ain't slander you, bro. There's no proof that my client, not what my lawyer is saying. Y'all know how, no. So let me show you what Byron, because he said I should have called him. Yo, it was a time when Byron Blake responded to every time I hit him. Let me show you how he been doing in the last year or so. Let's go up. I would have hit him like I used to. Look how long me and Byron Blake relationship go all the way back to, let's see. He says me and him back and forth. He's sending me shit, I'm sending him shit. Back and forth. You see me in the blue and the white. Are we back to (3/16/2024). This 2026, y'all. Then in 2 years. No, yo, peace out, could have hit you. This how I used to be. This before Everybody knew about him. 2024. Early from 2024. Y'all see them dates, so that shit too light. Are we down? So let's show the last couple. Let's start. Let's go 2025. When the 1090 Jake shit start exploding. All right, 4. Let's see. That's May 2025. 2025. Yes. The last time I hit Byron Blake, look, no response, no response, no response. That's an audio call. That's the last time I talked to him. Hit him about the shell kill shit. No response. I would have hit you, bro. If you was motherfucking moving like how you used to move. I don't know why you quit responding. I don't know. I don't know. You got to. I can't tell him why. Maybe why did you quit responding? I just thought you went Hollywood on a nigga for real. That's what I thought. Like, that nigga done went Hollywood, but I ain't say nothing. What happened? When he did a video and then you came over there zapping, and then you like, oh my bad, y'all was geeking. You talking about that? Cause you said you was geeking, and I wasn't tripping about that shit. I'm like, nigga, I ain't trying to slander you, my nigga. Fuck, nigga, you one of the only niggas I support on this bitch. I watch that up goofy ass niggas, bro. Only way I see Suddy Nash and them niggas is through your shit. Don't watch them niggas.
See exactly
Niggas
what
fucking,
I said.
Niggas fucking clowns. I disagree with what you said about what was it? I don't even remember the story was. And then you came over here like, oh, you clout chasing or some shit. Like, oh, what the fuck is you talking about? And then you admitted that you was geeking.
Pooh Shiesty's attorney quit. In this video, I cited a couple of things that
Is that not what happened?
Shiesty's father's lawyer argued at court, and a couple of things that Big 30's lawyer
Still gonna
argued
support your platform,
in
bro.
court. While I was presenting this, I was giving y'all.
Yo, but I'm saying he admitted it because in that context, for that hearing, it served purpose for his bail, for his argument for bail. You saying he admitted it, and you called it an admission, a judicial admission, which means that he has to stand on it. I'm saying that's wrong. That's the disagreement. That's the disagreement. I'm saying he don't gotta stand on that. I'm saying that's wrong. I'm saying, yo, that's not snitching. You allow people in your comments to run a whole narrative on this nigga, calling you a rat. Now you got other people making videos calling that man a rat. And you won't admit that you was wrong for that. Because it's not a statement. It's not a statement, yo. He's admitting to the gut. He's agreeing, not admitting. he's agreeing to the government's theory, because the government theory, he's agreeing to parts of the government theory. Let me say that, because he's not agreeing to the whole government theory. He's agreeing to the parts of the government theory and he's using that theory to create another narrative to show that, look, my client didn't do anything wrong. My client didn't rob anybody. My client didn't pistol whip anybody. At the most, my client was just under direction. But that's not what he's going to say come trial. You understand what I'm saying? You made it seem like that's what he has to say. Or look, he can say that come trial because they don't have no proof of nothing that we know of. They don't have a contract. They don't have a firearm. They don't have a video. So with them not, let's say, from what we know now, because we don't know right now, they could have it. But as of right now, nobody knows what the government got. Not even the defense team. Can we agree on that? Can we agree on right now the defense team don't know what the evidence they got? Yeah, I'm sure Big 30 in the interrogation room, if he signed over his Miranda rights, did decline being there. But you can't decline being there come trial. He can't deny being there come trial. How you gonna deny being there? It's pictures of them niggas there. You can't deny being there. I mean, you can, but that's not gonna be an adequate defense. It's not gonna be an adequate defense, bro. Now in the interrogation room, you can deny being there. When I got questioned about my case, I didn't know this nigga. I didn't make no phone calls. I wasn't there. I didn't, none of that shit. But if there was undeniable evidence as a lawyer, right? Say in my case, they found out that it was undeniable that I made these phone calls. Then now my lawyer got to be, well, he called him for whatever. Or, yeah, my phone call, but he ain't the one that made the calls. So the defense, so the prosecution will have to prove that I made these phone calls. Like Melly case. That's why Melly case went the way it went, because they couldn't prove that he made those calls. Yeah, that was his phone, but they couldn't prove, because it wasn't there and nobody else said it, that these calls was his. That he the one that pressed them buttons and dialed them numbers. That's all I'm saying, bro. Like, yo, you just missed, yo, you used the law and you didn't use it in the right context, bro. That's it. That's it. And at that sense, yo, you should do another video and explain to people y'all got it wrong, bro. Like, I got y'all thinking, if y'all, or at least say, yo, if y'all think that Big 30 is a snitch because of me, then that's not what I was alluding to. You know, I don't think he's a rat. You haven't done that, bro. And you see them comments. Just like everybody, we all see, it don't matter how many comments we get, we all see them. We all see them. You seen them comments calling you a rat, bro. You ain't replied to none of them. Or one of them you did reply to and say, "Oh, see, I said it. You know, you said it, not me," or some shit like that.
A couple of things that Big 30's lawyer argued in court. while I was presenting this, I was giving y'all a legal breakdown of what some of these terms mean. The thing is, a lot of these guys will discuss cases with you and they'll think that because they caught a case before, that means they know how the legal system works and all of that. But a lot of these guys, they look at these documents and they have no idea what the words mean that they are reading. They can read the words, but they don't have a clue what the words mean. And so it shows you how a lot of times guys go into court and don't even realize what's happening to them, because the lawyer is saying stuff and you only picking up certain parts and you just like, oh, that's what he means. But in reality though, it's something totally different. Now, when I made this video, blogger Keep It G News, which is actually somebody that I think is pretty cool. You know, we don't agree on everything, but I'm perfectly fine with agreeing to disagree. What I don't like is, you know, the videos where you clearly discussing me and what I'm talking about, but instead of just saying my name and hey, this is what's going on, you do like some passive aggressive stuff. And at the same time, it's clearly an attempt to discredit me. And the truth is, you are the person that's wrong. So I'm not gonna be hostile, but I'm definitely gonna make my point. You know, like I said, I like Keep It G News, man. You know, we chopped it up personally outside of the comment section a few times. You know, so I'm gonna take you to school one time here, bro, and I hope that you get this and understand this. You know, without wasting any more time, though, we gonna dive in to the clip first. First, I want y'all to see exactly what I said. Let's take a look at a recent document filed by Big 30. This was filed April 24th, and it says, as for Mr. Wright's undisputed conduct, basically saying this is something that we cannot dispute that happened. Retrieving a bag at another person's request, filming a document signing, standing at a door. The government argues each act individually reflects criminal participation. But these allegations, taken together, describe someone who was present and compliant with instructions, not someone who orchestrated or escalated the incident. The individual who directed that a firearm be produced was Lontrell Williams Jr. The individual who pointed a firearm at RD's head was Lontrell.
He's connecting. You see how he connecting all of this together? These are two separate arguments. He's not saying all of this is undisputed because he can't speak for Pooh Shiesty. You understand what I'm saying? Even with him saying undisputed conduct, he's not saying all of this is undisputed because he only speaking for his client. And he is disputing portions of the so-called evidence. Byron know what he did. His refusal to back off of it, I mean, I don't know why. But he know what he did, y'all. You made it seem like he's saying that it's undisputed that Lontrell Williams produced the firearm and pointed it at, like he's not saying that.
Lontrell Williams Jr., the individual who stripped the victims of jewelry was Lontrell Williams Jr. Mr. Wright is not charged with being Pooh Shiesty's equal in this alleged kidnapping robbery. Y'all see the point. Y'all see where this is going. So this is Big 30's lawyer basically saying, again, undisputed conduct means, you know, we not disputing this at all. Now, apparently, my boy didn't like my breakdown, and nor did he believe that the things that I was saying was factual. So he decided that he was going to take to his channel and make a video, which he's perfectly, is perfectly fine. He's more than entitled to do. I love a good challenge. But it was the caption. Look at the caption on the video as well. That kind of stung me a little bit. I'm knowing you responding directly to my content. I wish you would have just been like, man, Byron, let's debate or something like that. But whatever. This is what Keep It G News had to say.
Like, this is my thing with people, right? Yeah, I had to turn it up. That shit was aggravating. This is my thing, right? Yo, when you first get arrested. And the thing was, too, right? When I was talking about this, if y'all can remember, I played the video. I was talking about this nigga at the time. What's up, Kenna? Y'all remember I played the video? Fuck that shit go at. Is that yesterday? Man, we supposed to went live about something totally different. I was talking about this nigga right here. Remember? Israelite TV, Talk TV.
Were you recently injured in a car accident? If so, you need to stop.
I was talking about this nigga. Because this is what I was talking about.
Insurance companies are trying to remove a viral social media video that claims people involved in a car.
Right.
By him making those accusations, it made niggas like him pull up and do these type of videos. Big 30 rats on Pooh Shiesty. No question mark. Lawyers confirmed footage. Pooh Shiesty also told on Fed case. And all he did was do verbatim what Byron Blake did. Yeah, niggas is on that live, man. All right, let's get back to his rebuttal. We've been live for like 5 hours, fucking Byron Blake ass. It's hell of a shit I wanted to talk about. We're gonna do that shit later or tomorrow. I fucking might be tired after this shit. Hit that like button, subscribe to the channel if you're new, man. And you go to a bail hearing. All you have is the original indictment. Bail hearings aren't to dispute the facts of the case. We're the same people try to dispute the facts of the case at a bail hearing and the judge say no. That's not what we're here to do. So you got the defense team. There's so many factors that I just learned today that just doesn't corroborate with his narrative. Like I said, even with a judicial admission, you can't have that when multiple people is giving different accounts of the situation. Also, it has to be ruled on by a judge. In this sense, they haven't even had a bail hearing yet. It typically happens in closing, opening, or evidentiary portions of the motherfucking court proceeding. Not at bail hearings, y'all. I don't know why Byron is not trying to just acknowledge the facts. Like, you got this shit wrong, bro. God damn, it happens, my nigga. Like, shit. Got it wrong, bro. And it was egregiously wrong, yo. It was so wrong that now the internet is going around calling Pooh Shiesty, Big 30 a rat, man. That shit was dead wrong, bro. Shit was dead wrong, my nigga. You got the defense team using the indictment against the federal government, showing that based off of your own investigation, my client's role in this alleged robbery, kidnapping is minimal. Now you got YouTubers using that paperwork to say that these niggas is telling. These niggas is wild. Like, all the way wild. I'm legitimately upset about this, because it's fucked up, yo. Like, yo, for one, you not only putting smut on this man's name, but you also misleading thousands of people. You misleading thousands of people, yo, that come to these pages because they think some of these guys have a certain knowledge of law that they don't have, and they coming there to learn. And these niggas is over this bitch misleading motherfuckers, man.
Now, the first thing that I want to point out is that he completely changed the words up. The key thing that I want you to take away from this is that the attorney said, as for Mr. Wright's undisputed conduct, then he listed retrieving a bag at another person's request, filming a document signing, and standing at a door.
None of those are crimes. None of these are crimes, yo. It's not a crime of receiving a bag at another person's request. It's not a crime from filming a document signing. It's not a crime standing at a door.
These are the things that he says are undisputed conduct. If you look up the definition of undisputed conduct in legal terms, undisputed conduct refers to actions or behaviors taken by a party that all sides in a legal dispute agree actually happened. It is a fact, action, or event that is admitted, acknowledged, or unchallenged by the opposing party.
Exactly. Where he was wrong at was tying this into it being a motherfucking judicial admission. That's where he fucked the whole shit up at. When he tied this to that law, that's where you fucked it up at, bro. He just didn't. The lawyer mentioned things that wasn't a crime. It wasn't a crime. Yeah, but that's not what the lawyer said. The lawyer didn't say he kidnapped anybody. The lawyer didn't say a Draco came out the bag. The lawyer didn't say a Draco came out the bag. And they're not binded because a judicial admission is a binded statement. He didn't bind it. What he said can vary. So what if when they get the discovery and the feds don't have proof of any of this? Based off of Byron Blake theory, even if they don't have any proof of any of this, if nobody testifies to this, the government will be able to point back to this motion and say, look, you admitted to it right here. Nah, bro. Nah, my nigga, you dead wrong, bro. That's not how that shit go, man. You feel me? That shit don't go like that, bro. Cause that's what a judicial admission is. It binds you. It's a statement that you can't back away from. And we also learned today that you can't even have, and it has to be ruled on. It has to be ruled in a judicial admission. And we learned that it can't be conflicting statements. And we know that all of these guys are going to have their own narrative. So it can't be a judicial admission. And that's all I'm trying to get you to understand. And I think he knows that. He just don't want to admit it. that the law that you use to justify or to explain this, it didn't make sense. You tried to put a motherfucking a size 6 on a size 10 foot, bro. Shit don't fit. If it don't fit, it must have quit, man. Like OJ, man. The glove didn't fit.
So, undisputed conduct is Big 30's attorney saying, hey, yeah, he did retrieve a bag. He did stand at a door. He did film a document signing. That's what he's doing when he says, as for Mr. Wright's undisputed conduct. I know y'all be wanting to put y'all own definitions on stuff and sound smart, but bro, the words are the words and they mean what they mean. I'm not making this up. This is what's called a judicial admission. A judicial admission is a formal binding statement made by a party or their attorney during legal proceedings, such as in pleadings, testimony, or open court that removes a specific fact from content.
So pleadings, which means pleading guilty. Yo, we at the preliminary, testimony, evidentiary hearings, opening statements. Like yo, he just mischaracterized. He applied this where it didn't belong. No, y'all, that's what I'm saying. Don't be sleep. It's not hurting anybody. All they did was use the government's theory against them. That's it. That's it, and that's all, yo. Like he made it something that it wasn't. The government isn't saying Big 30 did anything wrong. You understand? They're disputing the intent. Let's say we're going to run with your narrative that he gave him a bag, he stood at a door, but those are not crimes, y'all. Now, where we disagree, this is where we disagree. Y'all saying that this was some type of plot. We're saying that he just was under direction. So why is he getting a no bond? Pooh Shiesty gonna do? I mean, Big 30 not gonna get a whole bunch of time. Like, I'm not debating if they're gonna get found guilty or not. I don't know. We haven't seen the evidence. We don't know what Gucci gonna do. Or the rest of them guys. You know, they can get up that bitch and play stupid. You never know. But he wrong, man. That's all.
Relieving the opposing party of the need to prove it. So what he's doing is saying, hey, y'all don't have to waste no time trying to prove that he did these things. He did do that, but he was just following directions. He wasn't doing this because this was his role, and he conspired with these guys to play this specific role during this situation. That's it, bro. If you want to turn that into I'm saying they telling, then you must feel like.
I guess that is unfortunate. And then he tried to switch it on me. No, nigga, you know what you did, man. I bet if we go to the comments of this video, it's people calling him a rat.
These things, he did do that, but he was just following directions. He wasn't doing this because this was his role, and he conspired with these guys to play this specific role during this situation.
And that's what I told him. He did the same. He did the same shit he said he was against, and he don't realize he did it. Or maybe he do. He just not admitting it. In this video, he did the same shit that he said that he was against, man. That's why I was disappointed. I don't know. It ain't even about him beating the case. It's just about, you jumped the gun, my nigga.
That's it, bro.
For real.
If you want to turn that into I'm saying they telling, then you must feel like that's telling. It's a judicial admission. And listen, to respond to what you were saying, yes, a judicial admission can be made at a bail hearing. You can make a judicial admission at any time during any court proceeding. It's a formal concession in court that dispenses with the need for evidence of a specific fact. Can be made by attorneys in court proceedings, pleadings, which is motions. It's a judicial, bro. A judicial admission. I can't say it enough, bro. You saying, oh, they don't have discovery yet and all this. They don't need discovery. Why would he need discovery to know his theory of the case? People make admissions all the time, bro. I'm going to give you a good example. Look at this.
Well, it was truly a courtroom shocker when the suspect, 20-year-old Terrell Gibson, spoke on the shooting. Now, Gibson goes on to detail his mental health struggles. Then he says that none of the victims died, but then goes on to admit, saying that he shot them, all within a span of 5 minutes.
I shot every one of them people in their head. They're not making it back.
The suspect, 20-year-old Terrell Gibson, faces several charges, including first-degree murder and attempted first-degree murder. Police say Gibson shot 5 people Monday night. It all started around 6:15 inside the Azure Estates community in Riviera Beach. The police chief says it appears Gibson was having a mental breakdown as he describes hearing voices in his head, insisting he get a gun and shoot people. Gibson fled and attempted to carjack multiple vehicles. Police say he then shot 3 more victims and ultimately succeeds in taking a vehicle and fleeing. According to police reports, one of the victims was his own cousin. In Gibson's first appearance on Wednesday, he repeatedly claims that he can see things that others can't.
I'm fighting something I can't even see. I see it at night. I see it now.
Yo, you use a nigga that got an obvious mental disability, bro. Like, he fuck around playing insanity.
He goes on to deny that anyone was killed during the shooting, but admits that he shot people in the head just minutes later. Attorneys in the room then warn him that anything he says...
No, y'all. He didn't make a judicial admission, y'all. Nobody is, nobody. No lawyer that's being paid is gonna make a judicial admission at a bail hearing, y'all. Like, it doesn't even make logical sense. That's why I don't even understand why he even went that direction. Yo, we ain't nowhere in the case, yo. Do people know how early the bail hearing? Yo, they didn't have a preliminary. They didn't have an arraignment. They didn't have anything. They didn't have anything. They didn't have anything, y'all. Right. And you is right too, Kenneth. He was the only one on trial. If he had co-defendants, it'd be different. And that's another thing too. Don't be sleep. You can't make a judicial admission when you got co-defendants and everybody got a different narrative. And in the video he did, he showed that everybody have a different narrative. Because Pooh Shiesty was saying he wasn't even there.
Can be used against him in his trial.
I don't care. I'm fighting something I can't even see. I see it at night. I see it now looking at you.
Look, so this is more misleading. Like, you just did another video misleading niggas further, bro.
Denied that anyone was killed during the shooting, but admits that he shot people in the head just minutes later. Attorneys in the room then warn him that anything he says can be used against him in his trial.
And mind you, he's saying this. It's not the lawyer. He is saying this. So you say, come on, Byron, this is intentional, bro. Sound you over there scrambling and scraping, my nigga. This is intentional. You know this is the difference. You put paperwork accusing Big 30 lawyer of doing this, but then your example is the defendant himself.
I don't care because I'm speaking the truth in my heart. I don't care about you saying I don't care.
That right there is a judicial admission. And if you think for a second that they aren't going to use that when it's trial time, you crazy. In fact, The attorneys told him, you heard the lady say, the reporter say, the attorneys told him that anything you say right now can be used. A judicial admission is a form.
Anything he say. Big 30 didn't say anything. They haven't even had the court proceeding yet. Like, they didn't even have this hearing yet.
Binding statement made by a party or their attorney during legal proceedings. The second you walk into that courtroom, bruh, it's all going on the record. They got a little stenographer sitting over there. You know that little lady that's sitting on the side of the judge that's typing? That's a stenographer. Her job is to type every single word that was said.
Yeah, you gotta have co-defendants. You gotta have co-defendants in order. I mean, you know, if you have co-defendants, you can't make no judicial admissions. You know why? Because that'll prejudice the other client. As a lawyer can't make no, let me say that. A lawyer cannot make no judicial admissions when there's other people on the case.
Her job. Every word that's said in the courtroom, she has to record it so they can double back on it and say,
"Hey, don't look crazy, y'all. It don't look crazy when you look at it in context. Don't be sleep when you view this in context. It look perfectly normal. Look smart. You gotta look at it in context of a bail hearing. You gotta look at it in context of the government is not alleging my client did anything violent. Look. What are variables that depend on a defendant getting a bail? I hate when I do that. What are variables depending on a bail hearing? She ain't gonna say it out loud, fucking stupid bitch. Like sometimes the bitch speaks, sometimes it don't. I don't feel like reading it. But risk to public safety, flight risk, criminal history and record, financial resources, previous bail violations, nature and severity of the crime is what it says. I thought I was gonna read it out.
So Big 30's attorney saying that this is undisputed conduct qualifies as an admission by Big 30 via his attorney that yes, he did in fact do these things. It's undisputed. Yes, I was there. I was in the room. I did grab a bag. I did close the door. It's self-explanatory, bro. So again, the difference between me and you and what we doing right here is you telling me what you think. You telling me why would a lawyer do that? I don't know, bro. You got to ask the lawyer. But you saying what you think. I'm telling you what I know. You see how I'm able to pull up these definitions and these words and stuff and show you and give you examples. You show me an example of anytime there was a bail hearing and a person said that they did something and it didn't come up. Like, show me. Give me.
He keeps saying a person. The person didn't say anything. Like, OTO, that's what I'm saying, yo. He's delivering this information. Like, these are big 30 words. Like, it's like we heard Big 30 say this in open court. Like we just heard the other guy do it. That's not what happened, y'all. He knows it's not what happened. I don't even know. Like I say, it shows his character. It shows his character by standing on that shit. When it's obvious you wrong. It's obvious you wrong, bro. And you standing on it. No, he does have co-defendants. You can't make a judicial admission. Your lawyer, because we gotta use the words correctly, because words have meaning. That's why he keep confusing people, because he keep making it seem like Big 30 is doing all this. Your lawyer cannot make a judicial admission on behalf of a client when you have co-defendants. Can't do that. Can't do that. That automatically disqualifies his point. Even if at court they do run with the narrative of he passed them a bag. Because I think that's probably the smart thing to do. Because they don't have any proof that a robbery happened. You understand? Pooh Shiesty can go on that bitch and say, yeah, I meant up for a contract. I wanted to sign out my deal. Hold on. You understand what I'm saying? So if Big 30 saying, because there's no only person that can testify to a Draco coming out that bag is Gucci. Long as Big 30 didn't say that in the interrogation room, long as Pooh Shiesty's father didn't say that in the interrogation room, long as Pooh Shiesty didn't say that in the interrogation room, you got 3 people saying that, yo, ain't nobody pulling no Drake out on him. Versus one person saying they did. Not saying that the jury won't believe that one person. I'm just saying we have an argument. We have a case. We got reasonable doubt. Long as Big 30 didn't go into the interrogation room and say, man, he just handed me a bag. You understand? Like if Big 30 said these things in the interrogation room to the police, yeah, he'd be telling. He'd be telling. He'd be a rat. But his lawyer doing it to try to minimize his client's participation to get him a bail, that ain't telling. And that ain't no judicial admission either.
Be an example, because right now you're talking a bunch of gibberish. Arguing the facts of a case at an arraignment, or that, okay, they'll stop you. Yeah, no, we ain't here for that. We here to find out if you're guilty or not guilty, you know, what you're pleading to, that type of stuff. A bail hearing, you are, in fact, arguing evidence. You are arguing why this person should be released. According to Big 30's attorney, his undisputed conduct does not qualify as conduct of a person who was conspiring. It's just, you know, yeah. So he's not saying that if he were, it would be in there. He would be saying my client wasn't even there. You see how Shiesty's father says he disputes being in the room? It's that easy, bro. Big 30's lawyer could have argued he wasn't there. But then people going to say, why would he argue he wasn't there if he don't?
At a bond, yes, evidence is argued at a bond hearing, but it is not a full mini trial. It's not focused on guilt or innocence. It's not focused on guilt or innocence. Instead, attorneys present evidence and arguments regarding the defendant's danger to the community, risk of flight, and ties to the community to determine if release is appropriate under what conditions. To summarize the evidence, you see what I'm saying? You don't go into the specifics. Discuss the severity of the charges. Present evidence of stability, such as employment, family ties, community involvement. Focus on whether the defendant is a danger to the public. While not trial, the strength of the case can be a factor in determining the bond. So that's what he was highlighting, the strength of the government's case. The role, when you go, all right, prime example, right? Y'all know I've been locked up for the same charge twice. Hold on, man. All right, so when I first got booked, right, the first time in 2005, y'all know I got locked up in 05, then I got grabbed again in 06. In 05, I caught a bond. On a first degree murder case, I caught a bond, $100,000 bond. You know why I caught a bond? Because compared to my other co-defendants, I was the youngest. I didn't have a record. Only had possession of marijuana charge on my record, and based off the evidence that the state had, I was least culpable. As far as my role wasn't as important. Like this is the state's third. My role wasn't as important as everybody else's, because the guy that snitched only said I was in a car. So my other two co-defendants, one of them they said was the shooter, another one they said was the driver. They was both older than me. This is the state's third. Well, they both older than me. They ain't the state's third. But their role was more important. And they both had more charges than me. They got a no bail. Now, the first time they threw everybody case out. My case, I bailed out. A week later, they dropped my case. That was bogus. Was mad as shit about that. Left my mouth with a fucking $10,000 bill. But eventually, everybody's case got tossed. They held the person who got snitched on too, that supposed to have been the shooter. They held him for 6 months. Dropped the case on him. They dropped the case on me and my cousin at our preliminary hearings. I said that to say, at a bond hearing, what Big 30 lawyer was trying to do was paint his client out to be the less culpable, based off the evidence based off the indictment, not even the evidence, because they don't have the evidence, just based off the indictment, and it's simple as that, yo. It's simple as that. Like, he made this something that it wasn't. He blew it way out of proportion.
Camera. Okay, so he's admitting that he was there. He's admitting that he did close the door. He's admitting that he did retrieve a bag. Big 30 may not even realize that his lawyer is doing that. He may not even, he's not there. He's not typing this shit up. That's why I say dudes be sitting back, letting the lawyers do stuff, thinking like, oh, okay, I got a good lawyer. He gonna handle that for me. Whole time, he in there admitting to some shit. And then you got a dude like you, Keep It G News, that don't even realize that he's admitting to. You telling me that you would let your lawyer file the same document. That's what you telling me. That if your lawyer filed this, you would have looked at it and been like, oh yeah, that's cool, and let it go through. Without really.
See, like, look, that's another thing. What the fuck is niggas talking about? Like, yo, what cases? I'm done with this. Yo, what cases have niggas fought where your lawyer let you proofread the documents? Like, yo, what the fuck is, like, a Byron? Nigga might have to get Byron big paperwork, man. Straight up. I think what my man was saying earlier in the comments. You might gotta pull your paperwork up, yo. Cause yo, what are you talking about, yo? Yo, whoever fought a case? Yo, a lot of us from Baltimore, man. And a lot of us have been in trouble that follow my page. Yo, how many times have your lawyer filed a motion and sent it to you first? like seriously though, y'all. Has that ever happened? Has anybody, if somebody let me know who been locked up before, like that did some time. Has anybody in the comments did time before and had a lawyer? Has your lawyer ever sent you a document before they filed it? Because why do niggas keep saying you're going to let your lawyer do this? Yo, when has that ever happened? Now somebody let me know, because I've never seen that before. Seriously. Whack 100 said that with text. Yo, your lawyer ain't, they're not sending you, they want you to proofread it. Here, make sure we put it in right. Man, fuck no. They gonna file a motion. And you fuck around get that bitch afterwards. Matter of fact, what you gonna get? You gonna get a letter. You ain't even gonna get the motion. You're gonna get a letter stating that a motion for the Wisconsin has been filed. Yeah, I got all these papers. I know I got it in my paper. I'm gonna find it when I look through it. It's gonna say, we have filed a habeas corpus motion for you in case number da 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 da. We're waiting to hear back from the judge, and we're gonna contact you once we do. That's all you're gonna get. Like, I don't know what niggas is talking about saying that you're gonna let your lawyer do some shit like this or file a motion for you. Yeah, I'm gonna let him file a motherfucking motion for me. The fuck, that's his job. The fuck. Yo, if you had a real lawyer, not one of them rinky dink ass lawyers, like a real lawyer that costs some thousands, that fight cases, that they got a name in your city, and they put a motion in for you. Yo, they not gonna wait to hear your response. Or let me see what he think about this one. What if you say, nah, I don't like that. Write another one. What the fuck are you talking about? Like, yo, what you gonna say? You know what? You looking at the motion. No, look, I want you to take this out, take that out, take this out, take that out. Yeah, and do it again. Now get the fuck out of here. That nigga might drop your case for that shit. Here's what this bitch just said. Here's what this bitch just said. Any motherfucking thing, right?
Realizing that he just admitted that you did everything that they said you did. He's not arguing that he didn't do it. He's saying, hey, he did it, but he was just following directions. That's the act of.
He's not, but he didn't say he did any crimes. That's another part he keep forgetting. He didn't say Big 30 committed any crimes. But that's not how Byron is presenting it. He's presenting it like he's admitting to crimes.
Of a person who following instructions, not a person who conspired. That's what he said, not me, bro. But I had to address this, man, because I see a lot of this going on, and it's like, come on, bro. You could have, you know what I mean? Like, just do your research, my nigga. Don't get on these platforms and make a fool of yourself saying something that you, especially not coming at me, bro. I'm going to keep it real. Like, go at somebody else, bro. You know, I get it. We all want to be, you know, him to a degree, but nah, bro, this ain't it right here. At least, like I say, have your facts together. Come show me something that actually backs up what you saying. Everything that
I think I did a good job of showing them just now. I think most people with sense knows that, yo, this nigga is wrong and I'm right. It's not no agree to disagree. This is a right versus wrong. I mean, I think most people can admit, if you being honest, it don't matter if you're a fan or a supporter of Byron Blake, you're a supporter of me, or you support both of us. That nigga is wrong. Straight up. Like, and I believe it like that, man. Make sure you hit that like button. Make sure you share the live. Make sure you subscribe to the channel if you're new. It's another day of KBG News. And if you watch that video on Byron Blake, man, flood them comments, man. That nigga wrong as a bitch. And I'm out.